and to ensure that resources are allocated for that task team to perform its specific task.
Mr. Matau,
Yes.
sorry.
Thanks.
General, what is the difference between a unit of SAPS and a task team? Do the legal prescripts distinguish between the two? So that's my first question. My second one is the PKTT. Was it a national intervention or a provincial intervention? And what's the difference between the two?
Legally, there's no difference between a unit or a task team. And the fact is, very often, a task team is a smaller group of people, cuts across different environments, for example, forensics and detectives, CI, which are all different environments, whereas a unit will have all detectives, for example. So a task team is more diverse. The second question, Commissioner, remind me, please.
Is the PKTT a national intervention or a provincial intervention? Because you say that paragraph 81 was one of the 11 national priority intervention operations operating in 6 provinces and one at national level.
Yes.
So I'm not sure whether PKTT is it a provincial or a national intervention but operating in KZN.
I believe it was a national intervention because it came from the Interministerial Committee. And in that regard, it related to other departments as well, and it was reported to the minister. So it is a national intervention by the police. And then you had another question?
I think you may have answered.
Okay.
Incidents of politically related cases were expected to increase because of the 2024 elections, and you provide the reasons thereof, correct?
That is correct.
Then I'd like you to proceed to the disbandment instruction that commences from paragraph 85 of your statement.
On the 31st of December 2024, the Minister of Police directed a letter to the National Commissioner directing that the PKTT be disbanded.
Yes, and then that letter you attach as VR4 in Van Rooyen 2. It is at pages 101 to 103. You don't need to go there. You quote the aspect relating to political killings task team. You recall that that letter has 3 items that it deals with, one of which you also address later, but for purposes of this aspect of your evidence, you deal with the directive insofar as the political killings task team is concerned, which again, we don't need to read into the record because the Commission has had evidence and has seen a copy of that letter. And if I can just ask you perhaps to deal with paragraph 87 and following.
It is important to highlight that in his letter, the Minister did not direct how the dockets under the task team's control should be dealt with. He did, however, direct that the disbandment ought to be done with immediate effect. I am informed that this determination of the dockets under the task team's control should be dealt on how the dockets to the task team should be dealt with was made by Lieutenant General Sibia in his letter to Lieutenant General Sintamule, dated 4 February 2025. That letter also makes clear that Lieutenant General Sibia claims to be acting on the instruction of the Minister of Police to disband the task team. And that letter is also part of my file too. The affidavit, the post...
So can I just ask you maybe, before you move to paragraph 89, to go to VR5 at page 105 of Van Rooyen 2. Paragraphs 3 and 4, you'll see in paragraph 3, in this letter from Lieutenant General Sibia, he says, on 31 December 2024, the Minister of Police issued a directive to the National Commissioner to immediately deactivate and disband the NTT-PK. This decision was informed by an assessment that the task team no longer significantly contributed to policing efforts. And before I go to paragraph 4, perhaps that question that Commissioner Khumalo was asking about whether it's, was it a national task team? In other words, national character, but operating from KwaZulu-Natal. There's the N part of
That's correct.
the PKTT. The N there stands for national,
Yes.
correct?
In this regard, it will be the National Task Team on Political Killings.
Right. And then if you then proceed to paragraph 4, which is where I want to ask you the question. It says the directive requires immediate compliance with appropriate measures to be undertaken to ensure the effective disbandment of the task team. And the following words are the ones that I'd like you to focus on, in accordance with current prescripts in this regard. Can I ask you 2 questions here? Or one question that covers 2 aspects. Are there prescripts within SAPS that regulate the disbandment of task teams? That's being the one question. And are there prescripts that relate or that regulate the transferring of dockets? If you can just ask, so if you can just deal with them.
Chair, I'm not
Separately.
aware of any instructions, either national instructions, standing operating procedures, or circulars that deal with the transfer or that deals with the dealing of dockets when a task team is disbanded. There's no prescripts relating to that. There is a national instruction on case management, and specifically that addresses the transfer of dockets from a CAS station, CAS being the crime administration system. When a complaint is reported to the police, it is reported on our CAS system, as I indicated, crime administration system. It is opened, and for purposes of statistics, it is reported on the system. For example, if a case of murder is opened, it will be registered as a murder docket, and a CAS number will be allocated to that complaint. And that CAS number is important because it enables a complainant to follow up on the investigation. It's almost a reference number. And of course, that CAS number also, or the docket retains that CAS number when it goes to court, and even when that case is completed in court. When the docket comes back after court proceedings have been concluded, that case docket is finalized on the system with a link to that CAS number. So we have a national instruction dealing with CAS in that regard. And the only provision in that instruction where, in my mind, would have been the appropriate place to deal with the transferal of dockets regulates the transfer of dockets from a CAS station, in other words, a computerized station that has access to a computer, to a station where there's a manual system, and how that docket should be transferred. In other words, from a computerized station to a rural station that may not have a computerized system, or vice versa. If it is reported at a small rural station that doesn't have access, and it needs to be transferred to a station that has CAS, that's the only instructions that I'm aware of, internal instructions dealing with transferal of dockets, which of course in this case it will not be relevant, because we are talking about cases that were reported in KZN, and CAS numbers would have been allocated to them.
Thank you. Then in paragraph 89, you attach extracts of an affidavit that the National Commissioner filed in the litigation that he testified on that had been instituted by Lieutenant General Sibia, and you attached that as annexure VR6 at pages 109 to 119. The only one point there to mention regarding that annexure is that some of us grew up aspiring to drive that car of a VR6. But other than that, there is no need to go into that annexure, because what that does, it outlines those engagements between the minister, the National Commissioner and Lieutenant General Sibia, where he sets out the first approach on the 14th of January with that proposed letter, which the National Commissioner did not sign. It goes to the 15th as well, where Lieutenant General Sibia approached the National Commissioner again. And even at the conclusion of that meeting, that affidavit also sets it out that it had not been signed. Then you have, from that affidavit, Lieutenant General Khumalo and the National Commissioner briefing the Minister on the 16th of January, 2025, and the following day, being the 17th, is when Lieutenant General Sibia decided to write that letter in his own name, which on both occasions when he approached the National Commissioner had refused to sign, and on the 15th he had said, leave this issue to me, I'll deal with it. That's really the import of what is contained in there, because you connect it later on in your statement. And if I can then ask you to deal with paragraph 91, this is after you say the evidence of the National Commissioner arising from that affidavit is that he worked with Lieutenant General Khumalo to prepare a report to the Minister on the alternative proposal to the disbandment, but that he never authorized the handing over of the dockets. Then if I can ask you to proceed from paragraph 91, concluding with 92.
However, Lieutenant General Mchunu, as a provincial commissioner, confirmed that he was never informed prior to the removal of these dockets, nor was he consulted on the possible disbandment. From April 25 to August 25, these dockets were stored at head office in compliance with Lieutenant General Sibia's direction. In September 2025, a joint media statement was released by the Ministry of Police and the National Commissioner, directing that the dockets head back to KZN. And this is part of my VR7, a newspaper report confirming the terms of his statement.
Yes, that's at 118 to 119. The National Commissioner testified on that and gave context regarding that media statement and how it was misinterpreted, because that process had commenced long before the postponement of the commencement date of the commission. Explained that properly in his evidence. Then the next topic.
Mr. Mutau, before you go to the next topic. General, focusing on the prescripts, we know what General Masemula said and what General Mkhwanazi said. Is it consistent with any prescript that you are aware of, whether it's the national instructions or other directives? Is it consistent with any of those for dockets to be taken from a province or a unit or a task team and be stored at national office for a period of up to 5 months without any investigations taking place?
No, Commissioner, it is not. And I think the first reason that raises alarm is it means the investigations are stagnant. Nothing is happening. On that investigation, you would expect the police to proceed as fast as possible and make a breakthrough. But the longer the dockets remain unattended, the more difficult it becomes to investigate that cases properly. Evidence get lost, witnesses forget with time, and therefore the investigation, any investigation, will be detrimentally affected if it is stored somewhere and no attention is it doesn't receive attention in the furtherance of the investigation.
Is that not, in your view, tantamount to the suppression of investigations?
It may very well be, yes.
And in paragraph 102 of your statement, page 35, you say this actually undermines the constitutional objects of SAPS as set out in section 2053, especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed.
Yes, sir. Yes. Especially if you consider evidence such as firearms. You know, as long as the firearms are out there, they can be utilized to commit crime. So you would expect the police to act as soon as possible to take the firearms into custody to ensure that no additional offences or further offences may be committed in the unlawful possession of such firearms.
Just out of interest, what does the prescript, you mentioned earlier that there was either a national instruction or some other document that dealt with the movement of dockets. Maybe if you can just repeat that evidence, and just out of interest, what does it say? Is it relevant at all to the case that we are dealing with?
Commissioner, it deals specifically with the administration of cases or the administration of case dockets. And the principle is they must be...
Sorry, please identify that prescript again so that we have it on record and then give the answer you're about to give.
It's the National Instruction on Case Management. And it deals with, as I said, the whole process when a case is reported to the police and it receives a CAS number, which is basically a reference number, and how the docket is opened, and the procedural aspects, not the investigation, but the procedural aspects of the docket. And it deals with the transfer of dockets between CAS stations and non-CAS stations, and the principle there is there must be record keeping. In other words, when it leaves one office or one police station and it goes to another police station, there must be record to indicate who received it. On the other side, when it arrives there, who receives it and the date. So that the principle is really, if after 2 months or after a period of time somebody is looking for it, you need to have a paper trail to see what happened to it and who signed for it, so that we can locate the dockets, and that it's not, it doesn't disappear or is lost somewhere in transit or at a station where nobody knows it went to.
Thank you.
Thank you, commissioners. Now we go to the substance. This is where you are now going to pull all of this together. Why these prescripts? Why these oversight mechanisms? After dealing with the disbandment, you're going to be dealing with whether there was a failure other than the Parliamentary Portfolio Committee on Policing, which did not do anything once it became aware of these allegations. And you are going to be discussing a question whether what happened here, which is on the version of General Sibia and General Masemola, if that evidence is accepted, is it an issue that relates to lack of oversight mechanisms or inadequacies of legislation, or you say it relates to something else? You start then by addressing the topic, is the disbandment policy decision or is it operational in nature?
And when, Mr. Mota, when you refer to General Sibia, that is what he has said, you are referring to what we see from the annexures, yes, because we are yet to hear his evidence.
Yes.
Thank you. Thank you.
Oh, no, sorry, not General Sibia. I apologize. Kwanazi and General Masemola.
Just as well, I
thanks.
The issue.
Thank you.
Thank you.
I tried yesterday to say I'm not going to rename, but I see that the opening person's chalice of poison has cascaded down. General, if I can then ask you to deal with that topic commencing from paragraph 93, where you say, from a regulatory standpoint. If I could ask you to take it from there.
From a regulatory standpoint and based on the legislative excursus detailed above, I am of a view that the decision to disband the PKTT as a task team lay within the exclusive authority of a national commissioner, and that the minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did. I say so for the following 6 reasons, one of which is in the alternative. Firstly, Section 206 of the Constitution enshrines the role of a minister primarily as that of providing policy direction at the national and provincial level. The Minister of Police is not a technocrat. His or her role is to advance the development of legislation and national police policy, particularly in respect of key issues that require executive attention. Therefore, a minister is empowered to select which areas warrant specialized intervention and attention, such as cash in transit, illegal mining, gangsterism, etc. However, a minister cannot prescribe or direct at an operational level, how policy is to be implemented. That is to be left to the National Commissioner, especially in view of the fact that this relates to the distribution and deployment of resources and has financial implications, which falls within the exclusive authority of a National Commissioner as the accounting officer of the Department of Police in terms of Section 36 of the Public Service Management Act. In the event that the Minister is of a view that a particular issue is no longer a priority and no longer warrants additional or specialized resources, the Minister is entitled to express that opinion or his position. However, its implementation falls within the exclusive remit of the National Commissioner.
And in fact, if I can just stop.
And what would the juristic nature of the expression of that position be?
I apologize, Chair. Can you just repeat the beginning?
You say that the minister is entitled to express that position. That is,
Yes.
if he's of a particular view that an issue is no longer a priority. So the minister is entitled to express that position. So my question is, what would the juristic nature of the expression of that position be?
Chair, for me, it's important that the Minister in his engagement, either as the Minister on political level or in his engagement with the communities, hear what they are saying. And if, for example, they say the gender-based violence is no longer a problem in our community. Let's hope that we ever get to that point in South Africa where we say it's no longer a problem. And the Minister then discusses with the National Commissioner that according to the community, gender-based violence is no longer a problem, therefore you don't need that additional resources. Then the National Commissioner can say, but Minister, do you know that gender-based violence is still a problem, and we've got statistics to support this or evidence to support that. So I don't think there's any topic that's off limit for discussion insofar as it relates to policing. However, the issue is the execution thereof and how it impacts on policing. That is the question where the responsibility or the involvement of a minister stops. And specifically to prevent political interference in the day-to-day operations of the police.
So the juristic nature would either be policy or direction.
That is correct.
Thank you.
No, thanks. I think the chair anticipated the clarification that I sought or wanted to seek. So you can proceed from paragraph 98.
Secondly, the National Commissioner is called in terms of Section 207 of the Constitution to exercise control over and manage SAPS. The National Commissioner remains responsible for operational control and resource allocation or distribution. Again, where a minister identifies a priority area, the task of how to implement and what resources to deploy rests with the National Commissioner. In circumstances where the ministers say that a particular issue is no longer a priority issue, then it is within the remit of the National Commissioner to determine how best to operationalize that expression. Turning to the facts before this Commission, the Minister unlawfully strayed into the constitutional competence of a National Commissioner when he issued a letter for the disbandment of the PKTT. What would have been an appropriate and take steps to align it with his directive. It can never be appropriate for a minister to instruct the National Commissioner not only to disband the PKTT, but also to say that the disbandment must be done immediately. That constitutes not only an usurping of powers of a National Commissioner, but also undermines the constitutional objects of a SAPS as set out in Section 205(3), especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed. Thirdly, due to the nature of the offences under investigation, a task team like the PKTT is privy to politically sensitive materials, and its dockets would need to be treated with the same sensitivity. The dockets could not simply be taken back to their respective police stations and investigated in the normal course. I say this because politically related cases are highly organized and are executed through different role players, such as hitmen, spotters, coordinators, and persons who ordered the hits. In addition, they typically involved a conspiracy implicating well-resourced senior politicians and business persons.
Before you go on, you preface your firstly to, is it finally or lastly? Finally at 110. You preface those by saying that what the minister did not have a legislative basis or foundation. I read what you say under your thirdly, that is paragraphs 103 and 104, to address an issue of implementation and not so much a question of legislative entitlement. Do you get my point?
Yes.
So, which would therefore mean that 103 and 104 do not really fall under your preface.
Chair, it would relate more to the implications, but you are correct in your assessment. It does not deal with the fact that he didn't have legislative authority.
So as not to waste your time, let me make a similar point, and I will not ask you to comment. I take the same view with regard to your fifthly as well. That too does not relate to legislative authority or legislative entitlement or lack thereof. Just look at your fifthly. Do you agree?
Yes. Yes.
Thank you.
It does not refer to any power or role of a minister.
Yes. I interrupted you when you were to go to 105 under your thirdly.
Therefore,
Sorry, Chair, and I think perhaps to complete that line of references that you have given, 101 would equally fall there. In other words, no challenge to the competence to issue, but the implementation.
Maybe we would have to look closely at that, because I think secondly, under which 101 falls, does deal with a legal issue. And then what follows right up to just before thirdly is a substantiation, or is intended to be a substantiation of the legal issue. which is the secondly.
Thank
But
you.
we will have to look closely at that, Mr. Mutale.
Thank you, Chair.
Thank you.
Yes, then please proceed from 105.
Therefore, the appropriateness of a directive to handle these dockets in such a manner when their contents stood to destabilize and potentially implicate senior politicians and established business persons should be determined by the Commission. Fourthly, the PKTT was created in collaboration. It has its genesis in President Ramaphosa's tasking of an interministerial committee comprising of the ministers of police, SSA, defense and military veterans, justice and correctional services to establish a multidisciplinary team to address the ongoing scourge of political killings in KZN. Thereafter, an integrated multidisciplinary task team consisting of members of the police,